Today is April 6, 2017. Today is the day that Annie's Law, otherwise known as House Bill 388 or the Ignition Interlock Bill, goes into effect in Ohio. This bill gives people convicted of an OVI the ability to request unlimited driving privileges if they agree to install an ignition interlock device in their car. Unlimited means you can drive anytime you want for any purpose that you want. An ignition interlock device is a device that hooks into the ignition of your vehicle. And the idea is if you have been drinking or you're too drunk, if you blow into this device, it will not allow you to start your car. In fact, even if you were to start your car, they have rolling rechecks. So the device will prompt you to blow into it while you drive down the road. The law even requires that if you exercise this option and request it of the court, and the court grants you these unlimited driving privileges, the court must suspend all jail time, and they can't put you in jail, at least not initially, and that jail time is suspended. It also allows for the judge to cut a year-long suspension in half. So in Ohio, if you're convicted of a first OVI, you must be given a 1-year license suspension. However, if you exercise this option and the court grants it, they can cut your 1-year license suspension down to 6 months. This option may sound appealing to the average person. However, the choice is not quite that simple. If a person violates their privileges or has an ignition interlock violation, the law states that the court shall impose the jail time and extend the length of the driver's license suspension. While you might think that you would never make the mistake of drinking or being drunk and trying to start your car with this device installed, you don't need to be drinking and you don't need to be drunk in order for this device to report a violation. In fact, until the year 2020, these devices are not required to be equipped with cameras. So even if someone else triggers a violation in your car, it will be attributed to you. If you think you would never allow a drunk person into your vehicle to blow into the device, and that makes you feel safe, that's a false assumption as well. Even if you are the one blowing into the machine, and it is only you using your vehicle, there are a large number of substances that can trigger a false positive in these devices. And that can lead to a violation and jail time. This includes mouthwash, chewing tobacco, certain energy drinks, menthol cigarettes, spicy foods, and foods with yeast, such as bread, donuts, pizza dough, etc. A major problem with the law and its implementation is that it states that following a violation, you can appeal this violation, and a judge may give you a hearing. The law does not require them to give you a hearing and explore the circumstances of your alleged violation. So they don't have to give you a hearing to see if somebody else is the one who blew into it, or if it was something other than alcohol that gave this false positive result. The way the law is written, if you're eating a sandwich and the yeast from the bread is read by the device as alcohol, your ignition interlock company will report to the court a violation. And as a result of this, you may be put in jail and have your license suspension extended, and there might be not one thing you can do about it. As an example of the problems that these machines have, I am here in my office at Quinn Legal Associates. It's about 2 in the afternoon, and I have with me an AlcoSensor 4, and I have some bread. An AlcoSensor 4 is a portable breath testing device that uses the same fuel cell technology employed by ignition interlock devices and is commonly used by police in DUI investigations every day in Ohio. I am completely sober, and this machine can verify that for me. A fresh mouthpiece. The machine will read the temperature. It will prepare to receive a breath sample. Then it will tell me to test. We'll process the result, and it will show triple zeros, 0.000. And that's my BAC, because I am sober and I haven't had anything to drink. Now, I have a piece of bread. And like in my example, say I'm finishing lunch and I have to get back to work. I'm going to finish my sandwich and I'm going to jump in my car and try and start it with an ignition interlock device. So I'm going to eat the bread first and we'll see what happens. Just reading the sample. .021. If you have an ignition interlock device in your car and you blow a .02 or more, your car will not start. It will be reported to the court as an ignition interlock violation. Eating a piece of bread and blowing a .021 into an ignition interlock device means you do not pass go, you do not collect $200, and you go directly to jail. This is the danger of submitting yourself to testing on this machine many times a day. This is a very serious matter, and anytime you're facing a DUI charge, it is extremely important to have an experienced DUI attorney defend you and counsel you through these issues. Call Quinn Legal Associates and we can help you.